Good morning, happy Friday, and welcome to the Courtroom Files live show. A little bit early this morning has been our trend this week, but apparently I still have to wake myself up enough to talk. Let's start this morning in Judge Elmore's court. This is in Wexford County, Michigan.
Appearances from counsel.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Jessica Carl. I apologize for not rising, Your Honor. I need to plug in my computer.
You need to go get your computer?
No, it's right here.
Oh.
We'll get in.
All right.
This is an older machine. The battery doesn't have the oomph it used to.
Oh,
But then again,
we don't all have what we used to. Also here today is Mr. Kevin Stapleton, an agent from the Department of Corrections. And joining us today via Zoom from the Wexford County Jail is the defendant, Jessica Marie Carl. All right, we are here today for a motion regarding bond filed by the defense. I have read that motion, and I've also received a response from people. Mr. Harrison, go ahead.
Well, Your Honor, obviously, there's not much more to say into the record of this. There's the obvious pronouncement of her criminal history and all of the reasons why the prosecutor is expressing a great deal of confidence in their ability to obtain a conviction in this matter, et cetera, et cetera. And I realize that's all required under the applicable court rule. The fact remains, however, the original question that I posed to the court remains unanswered. Is the current bond excessive under the circumstances based on all the criteria in the court rule? We would believe, we would state to you with an open mind that it is in fact excessive to have $250,000 bond in this matter. She couldn't possibly post that. She's entitled to a presumption of reasonable bond, and this bond ain't reasonable. Thank you. Yes, I did say ain't.
It's okay, I thought about it, I heard it. So, Mr. Carnes.
Thank you, Your Honor. Just to really highlight Ms. Carey's response, paragraph 6E, as far as the likely sentence here, we score defendant at 58 to 171 months as charged. We do believe there are very strong proofs in this matter with a high likelihood of conviction. The defendant does have prior controlled substance crimes and a prior OWI. This is a very serious offense. Someone died. And the defendant, now skipping to paragraph 6I, does show a lack of remorse based, I think this is based on a jail call. I discussed this briefly with Ms. Carey. The statement insinuating this isn't a serious offense because of the victim's age.
How old was the victim?
74, I believe. Maybe even 64.
Okay.
It ends in a 4.
To me, that's concerning because that suggests a likelihood of recidivism and does suggest the defendant poses a extreme risk to the public based on this behavior. For those reasons, I think bond is appropriate where it's currently set, and I'd ask the court to deny defendant's motion.
Thank you. To tell me a little bit about this accident here. Occurred out on Boone Road, 39 Road. I see that.
34 and 39, Your Honor, there's an intersection.
Yep, I know it well.
Two vehicles came into contact.
But did one cross the center line?
There's an allegation that the defendant's vehicle failed to recognize the stop sign or a stop sign.
It looks like it says here she was doing 63 miles per hour.
It's
All right,
the UD 10 says that, yeah.
Yeah.
The state police accident report.
All right, was she on that, at that intersection, she would have been on 39 Road approaching 34 Road.
He was heading southbound, yes.
Correct.
And the victim was headed westbound or away from town.
Right. Yeah. There's that universal rent-to-own on one
Yeah, right there on
side
the corner.
and an old church or old, that may have been turned into a house on the other corner. Yep, okay. Yes, sir.
Your Honor, there was a third-party witness who observed and going to testify that the defendant disregarded the stop sign.
And did she go to the hospital?
Refused treatment. Her injuries were superficial at the scene.
Okay, and so.
She was trapped in the vehicle for a period of time and had to be extricated by EMS. Henceforth, I don't know how we're even considering any indicia of reliability in any statement she may have made thereafter, but.
Well, here's what I'm getting at. Was it a blood draw then?
Yes, Your Honor.
All right, and the blood draw came back with what?
0.04.
For alcohol, we're still waiting on a blood draw for controlled substances. Defendant did make statements about being prescribed hydrocodone, Norco, and Klonopin, all of which have warnings. Not
Right.
And she has MAPS history as well, Your Honor. There's no point in denying that these are prescribed medications.
So, hold on. What formed the basis for the count one, a combination of alcohol and a controlled substance? How do we know, or what was presented at the prelim to demonstrate that there was a controlled substance?
There was a preliminary blood test that indicated the presence of, I believe, all three substances mentioned. I'm not gonna, don't quote me on that. There was documentary evidence involved.
All right, go ahead, Mr.
I would assume, Your Honor, and I just picked up this file yesterday.
Sure.
I think that's a hospital blood draw, and we prefer MSP lab. That's why I'm saying it's the
We
way.
have different cutoff levels, but
Yeah.
so I'm sorry, you said a hospital?
Yes, Your Honor.
So why, that's why I asked about the accident. How did the hospital end up doing a draw?
Deputy Howard obtained a search warrant for chemical testing, which included a blood test.
Okay, all right, now I understand. All right, and what was the result of that again? I heard the 0.04, got that, that's not awkward while intoxicated, although most people misunderstand the statute. It's 0.08 is a per se. It doesn't have to be 0.08. It could be less, but which I see is probably why you guys charged it as visibly impaired. So what did the blood draw say regarding the controlled substances?
Detected aminoclonazepam, and nordiazepam. This is one of the blood test results that was returned on March 11th.
Take a look here.
I think there's another one too. Let me find it.
While he's scanning through his documentation, a more formal good morning, everybody. Welcome to the Courtroom Files Live. It's actually a little bit of a quiet start out there. I've only got eyes on 3 courtrooms at the moment, but generally on Fridays things tend to pop off, so just waiting for the action to happen. But in the meantime, this again is Judge Elmore. He is in Wexford County, Michigan.
Simply introducing evidence that she may have been intoxicated.
Well,
The finding of actual approximate cause, and et cetera, et cetera.
Mr. Harrison?
Everybody take a break. I want to know the answer to the blood draw. Where does she reside, Mr. Harrison?
In St. Louis, Michigan,
Okay.
middle of the Middleton, if you will.
Yep, I know where it's at.
Your Honor, my apologies for the statement. I do have MSP lab reports showing hydrocodone.
Numbers that
And, various benzodiazepines.
All right. All right, thank you. Don't understand how there could be much of a challenge for proximate cause if there's at least while the court does not make any findings beyond a reasonable doubt, that's not a burden of proof required at this level. And of course, I don't make any such findings, nor do I want anything I say to be interpreted as making such findings. However, for consideration of probable cause at this factor, we're considering bond under Court Rule 6.106. Person who, where there's some evidence that she had alcohol in her system in addition to opioid in her system, some level of alcohol. It's either going to be an operative while intoxicated or under the influence causing death. If someone is driving through an intersection ignoring a stop sign at 63 miles per hour, that sure sounds like proximate cause to me. Court finds that at least for this purposes, and likelihood of conviction. And with that, I see she has a have.
At 3, Your Honor.
it is a.
She's looking at a maximum of up to 30 years. And looks like the guideline range everybody's scoring her at is definitely putting her, even if it's in the middle of the road, at 10 years. Not saying that's what it would be, but statistically just picking a middle between those two numbers. Not that the guidelines are mandatory. That's a 30-year prison sentence. Does she have employment?
She did, Your Honor. She has a young child at home. I think he's about 1 year old. So it's been a temporary situation where she has not been returned to work full time.
Okay. Where is this? And she's 42. Where does this? I can't believe I'm asking this question. Her 16-year-old boyfriend live here?
There was a young gentleman with whom she was spending time that evening who does reside here in town, yes.
How long has she lived in St. Louis?
Off and on for, well, that neck of the woods, Your Honor. She's also lived in Alma for a while. That's kind of what she considers home, that area of the state.
All right. Okay. Yes, the court is to set a bond, consider bond that, of course, if you set a bond that's too high, that's like setting no bond. I understand that. What I don't know here is I don't have much information about employment. I don't have much information about family where they reside. I don't have any information about ability to obtain assistance financially from other people. The likelihood we've already covered, the likelihood of a prison sentence I've already covered. And I'm also looking here at these offenses which she's already been convicted. She has a criminal history that stems back about 23 years. And what I see are repetitive acts of domestic violence.
Can I speak to my lawyer,
Fine.
please?
No, ma'am, not right now. 5 convictions for domestic violence. But what's even more concerning to me is, besides her violent tendencies, I see six crimes of dishonesty, which it may not be admissible through the rules of evidence, but she has a record of, she had one in 2002, so she's going to have one of those that can be used against her. And she just had a very long intoxicated about 4.5 years ago.
Well, Your Honor, there are bond conditions already in place. For example, she is required to surrender her driver's license, but submit to GPS tether with house arrest.
I see that.
Okay.
But all right, the court will in part modify the bond as follows, but please note, it ain't gonna be much. The court will reduce the bond from $250,000 to $200,000. All the other terms and conditions apply. That will not be a 10%. That will continue to be a cash surety. We have significant criminal activity alleged. The likelihood of conviction appears to be very high, and the likelihood of a prison sentence, at least for the burden of proof required at this level, definitely supports that there would be potential prison sentence of in the neighborhood of 10 to 30 years. So, and I've got prior crimes of dishonesty, which demonstrates that does not help the defendant. By the way, I keep saying this, and I know the probation office is very busy, but I would really like to know how her probation has been in the past. Has she violated probation? Things like that. Those are things I want to know. But without knowing it, that's the answer to the court today. All right. Thank you very much. We are adjourned.
Alrighty, good morning again. Welcome to the Courtroom Files Live. Judging from the chat, it looks as if we have some new people out there this morning, so welcome. It's good to have you here. We hop around a little bit. We do this show every morning, weekday mornings, Monday through Friday, 10 a.m. Eastern, 7 a.m. Pacific. And I've got a big monitor in front of me with as many as 14 courts going at once, and I kind of flip around based on what's going on, and we talk and we have fun, and that's kind of what we do here. That's in addition to all the other content that we have. We have long-form content, shorts, all of that. So, again, if you're new to the channel, welcome. It's good to have you here. I'm going to take us over to Judge Simpson now. A few minutes ago, he started his jury settlement docket, so let's say good morning to him.
Matter will be
April 21st at 1 p.m.
April 21st, 2025, 1 p.m.
Can I briefly address bond or something?
Sure.
Your Honor, I do understand that sentencing is set for pretty soon, it's on the 21st. We are respectfully requesting the court would consider modifying bond to a PR in this case. My client does state to me that he does have the support of his mother and that he has a FOC issue in Lenawee County he would like to take care of. With respect to requesting the court would consider a PR bond at this time.
Okay, I'm not going to need a response. I'm not going to change the bond until such time as at minimum probation has talked to him. So I will look at it after that. All right.
Understood, Your Honor.
All
Thank you
right.
very much.
Thank you. Bond continued. Court does call the case of the people versus Nicholas Minahan.
Middleton on behalf of Your Honor.
Good morning, Your Honor. Jeremy Clinton on behalf of Mr. Nicholas Manning. I'm standing to my right.
I thought that was you over there.
Yeah, I'm here today.
You know, it's been a long time.
I like spending my Friday mornings with you, Your Honor.
Is that what it is?
It
Okay.
is.
He doesn't call, doesn't write, no phone calls, no. Anyway, what are we doing?
We have reached a plea in this matter. Mr. Minahan will be pleading to one count of domestic violence, no contest, under 769-4A. We've also reached an agreement as to the no contact provision. We agreed to no unwanted contact to facilitate parenting exchanges between the parties after the no contest plea.
And that's correct.
Okay, gotcha. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear a firm testimony about the truth or the
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of domestic violence. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
Two things about it. I have to make sure you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. Do you understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead? Now you understand that by pleading no contest, you will not have a trial of any kind. All right. You signed an advice of rights form today, is that correct? Any questions regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those, or pleading no contest, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 248566. Any objection to the court having reviewed that report?
Oh, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be May 5th, 2025, 1 p.m.
And Your Honor, if possible, may I ask the court if I could appear via Zoom that day? I will be out of town in Maryland, actually, with my wife.
I don't think he's gonna be in Maryland. I think he just said that because
I really will be.
I think he said that just so I might say yes.
You may have seen the Terrapin mug sitting there, but I.
Yeah, okay, all right. Yes, we can, there's a form that you have to fill out, and just submit it to us. We'll take care of that for you.
Thank you.
All right.
Bailey, thank you so much for becoming a channel member. We really appreciate that. Goes a long way towards helping us, and we like the little extras that we give you. One thing I will tell you, we are going to be working at the bottom half of the month here at really building out the members-only video list. So look forward to that. Again, thank you so much. Welcome to the community.
There is not, to my knowledge, there's a PPO that's expiring in the very near future, a couple weeks.
Okay, so the PPO says no contest,
Correct.
does not give a exception for,
Correct. And that expires, do you know the date? Early May, I can confirm that date with the court.
early May.
Yeah.
Okay, so even if I were to order it, I think the more restrictive order is going to apply. And so he would be, I don't want to put your client in a position where he's following my order and then violating the PPO.
Right.
So what I will do is I will grant that because the parties agree to that. However, I will not sign an order to that effect till after the expiration of the PPO.
Thank you.
Okay,
And
so
follow up with Ms. Welding with the date of the expiration.
yes, once. So you can do it one of two ways. You can submit an order to the court now indicating that it will go into effect once you figure out the expiration date, or you can wait till the expiration date, submit an order to the court, and I'll do it. So either way you want to do that. All right. Fair
Thank
enough.
you, Your Honor.
All right. Thank you. All right. Enjoy Maryland.
Thank you.
Everybody's gonna get up here thinking I'll get my way if I just say that's where I'm going. Court calls the case, People versus Anthony Ned.
And then on behalf of the Honor,
Yes, he's in charge.
Good morning, Mayor. Please, Court Your Honor. And Damien Cash on behalf of Mr. Anthony Ned, who is appearing in the court with me via Zoom by permission. Mr. Ned, state your name for the record.
Sir. All right, what are we doing?
Now, now that the prosecutor proceed, is there enough to go forward with charges?
at this time, people are unable to proceed.
Do you have a motion, counsel?
I do have a motion, Your Honor. My favorite motion. Your Honor, without being able to confront the accuser, I have motion to dismiss this matter.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Ned.
Thank you.
Court does call the case of the People versus Franklin Fisher.
And then on behalf of the Honor,
Robert Hamburger, car number P 14570. To my right is Franklin Fisher.
All right. Sir, state your name.
Michael Fisher.
All right. What are we doing?
and at this time, people are unable to proceed.
You have a motion for me, sir?
Yes, Your Honor, I would move to dismiss.
All right. People being unable to proceed, this case is dismissed. That's without prejudice. All right. Thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case. People versus Stephen, is it Grisbeck or Grisbeck?
Defer to the court, Your Honor.
And then on behalf of the people, Your Honor,
Good morning, Honor. Sam Bernstein with on behalf of Mr. Grisbeck.
Your name? Thank you.
We are doing the opposite of Mr. Cash's favorite motion this morning, Your Honor, which is we're going to be pleading guilty.
Okay. Pleading guilty to the charge of domestic violence. Has he signed an advisory form?
It's not, Your Honor. We went over that, but I will have him sign one.
All right, may I have him sworn?
Raise your right hand. You solemnly swear affirm the testimony about the truth, the whole truth, nothing but the truth, so help you God. State your name.
Stephen Bridgeway?
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. Is that correct? That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that? Understanding of? Pardon?
Here's a second concern.
You're correct. So, you'll be pleading to domestic violence second offense. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that, sir? All right. And understanding that you still wish to plead guilty? All right. To that charge, how do you plead? And you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Look at paragraph 5, you'll see it on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of rank. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record, which is not anything, to get you to plead to this charge? Anybody threaten you or coerce you? You're doing this voluntarily, of your own free will, and because you believe that you're guilty of this offense? All right. September 2nd, 2024, at the location of 3121 Scenic Lake Drive, number 14, Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding a Samantha Smith that makes you think that you're guilty of this offense? All right. And who is Miss Smith to you? Okay, so you have a child in common? All right. And you did that, the push was intentional, is that correct?
Yes, sir.
All right. And had you previously been convicted of a similar offense on or about May 24th, 2021? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 21st, 2025, 1 p.m.
Your Honor, I know I saw the bond argument like just before mine, and it probably takes some cues from that similar situation. It seemed like.
But you're not going to do that, right? No, go ahead.
Modify at least what I was going to say. We're hoping for release after he speaks with Miss Pollara. He's been in jail now for 2 weeks and a couple days, and
okay, so when probation gets down and speaks to him, they'll be able to give me some additional information to help me make the proper recommendation. The other thing that should be noted is his sentencing is about 10 days away.
Sure.
So,
And Your Honor,
yes.
people also wanted to add, if he is released, we would also like to add the victim's place of employment to the no-go to the bond conditions. If it's not already. I believe she changed her place of employment, what was originally on.
Did they give, well, on the original order, does it just say place of employment or does it give a specific address? Because it should be a general.
On our no-go to, at least on our bond form, it was only her residence.
Oh, it was only a residence. Okay, so at this time, what I will do is I will add to his bond condition, no go to victim's place of employment. All right, so I'll add that at this point, so that way if he's released, that will also be applicable. You understand that, sir? All right, very good. All right, thank you.
Thank you.
All right, let's go over to Judge Fleischer. He is the king of arraignment Fridays, generally speaking. So if it goes as usual, it should be a fairly busy morning in his courtroom.
Stand. I don't care what you have to do, where you have to go. If the car doesn't have an interlock, don't drive it. We are sending notice to DPS in Austin so that every single officer in this state knows. So if you get pulled over, They're going to know that you need one. If you don't have one, they're going to take you to jail. I'm also ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. Because you have a lawyer.
He already has the interlock on the car, Judge.
Great. Okay, so just provide proof to them, or they should be able to look it up, and then we're all happy. Just don't use. You understand? Because you
Judge.
have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but stay in touch with Mr. Bresson. He'll tell you if and when you have to come back to court. If you pick up a new case, if you're a danger to my city, if you just, it's not going to go well for you. Do you understand? Okay, guys,
Thank you, Judge.
please. Ready? Please.
Appearance on Anthony Valerio.
What's the last name?
Valerio's the last name.
Okay, you need a translator?
No, he does not.
I'm bringing him up.
Come on, sir, okay. Yeah, sure.
Drug type 19.
Yeah, right here for you. Come on.
Good morning, Mr. Valerio. For your charge of driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
On April 6, 2025, in Harris County, Texas, an officer received a call to assist the department regarding a driver passed out in a drive-through of a Burger King restaurant. The firefighter told the officer he saw the defendant passed out behind the wheel, the engine still running, and the key in the ignition. Firefighter woke the driver up, and eventually, when the officer came on scene, he identified the defendant by his Texas driver's license. The officer noticed the strong odor of alcoholic beverage, glossy bloodshot eyes, slurred speech, and unsteady balance from the defendant. The defendant also appeared confused. The defendant stated he left Bango's bar and where he had one Corona beer. The officer conducted standardized first sobriety test where he witnessed 606 clues on the HDN test, 6 of it on the walk and turn, and then read the DIC form. The defendant refused. A blood warrant was signed and blood draws.
Right, sir, I'm going to find that there is sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. Do you understand? Do you have any prior DPIs and a license?
And the license is eligible.
Okay, you're not allowed to drive unless you also have valid liability insurance in your name. That is a condition of your bond as well. Do you understand? No alcohol, no illegal drugs. Do not pick up any new cases, otherwise you will go back to jail. I'll have you sign a receipt with Ramona. We'll have you get with Fleischer your bond conditions, and after that, you guys are free to go.
Thank you, Judge.
Guys, this was new again?
Valeria, copy page 19. Can I talk to you for a second?
Yeah.
Give me 1 second.
Sure.
Spanish?
Could be quick to get report problems.
For regulars tuning in who might be looking for my co-host Ellie, our 1-year-old kitten, she is, I believe, off playing with her sister Io right now. Since Judge stepped away, let's go back to Judge Simpson.
Court calls the case, People versus Gakik. Is it Vartanian?
Ashley Lonnie with people.
Vartanian, I think it is.
Assistant Public Defender Natalie Pate, on behalf of the Martinian, who stands to my right. Please state your name for the record, sir.
Got you,
Okay.
Your Honor, we are set today for final settlement of this time. People are unable to proceed. Motion to dismiss.
People being unable to proceed. This case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you.
Your Honor.
Court does call the case of the People versus Joseph Williams.
And it's on behalf of the people.
morning, Assistant Public Defender Mark Perry, on behalf of Mr. Williams. Mr. Williams is not present. For the record, I asked for an adjournment.
That was gonna be more, but okay. Joseph Williams. You know, response bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash share. That warrant will issue immediately.
Judge Fleischer is back on the bench now, so let's go back to him.
I'm bringing him.
Yes, Your Honor. Mr. Leday, please come on. In the middle. Come on in. Yes, sir. No, sir. You don't have to say anything.
You are Trevion Leday.
So,
Mr. Leday, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On April 5th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle tailgating another vehicle, failing to maintain a signal lane with other vehicles around it, and driving on the shoulder, and failed to signal a lane change. The defendant also was swerving between lanes, and the law enforcement officer initiated a traffic stop and made contact with the defendant. Law enforcement officer noticed a strong odor of an alcoholic beverage, slurred speech, lethargic demeanor, and watery, bloodshot eyes. The defendant admitted to drinking at a baby shower. The defendant was also unsteady on his feet. The law enforcement officer conducted the standardized field sobriety test and observed 6 out of 6 clues in the HGN, 4 out of 8 on the walk and turn, and 3 out of 4 on the one-leg stand. Defendant refused to provide a specimen. That is all I have in the DIMS, Your Honor, although I know from the official report that there was a blood warrant signed and executed.
Okay. Any prior DWIs?
No, Your Honor, his license.
Okay.
and he does have insurance.
Mr. Leday, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to test you if I find that you're using. It's not going to go well for you. Do you understand? Do not pick up any new cases. Listen to your lawyer. He will take care of you. Because you have one, I will waive your appearance. You have to stay in touch with him. He'll tell you if and when you have to come back to court. If I find that you're a danger to my city, you pick up a new case. You're using, I don't care whether it's marijuana, alcohol, anything. I'm going to put you in jail. Do you understand?
Yes, sir.
I'm going to have you go to Ramona, sign a reset. We'll have you get with Fleischer if your bond conditions, then you're free to go.
Thank you, Your Honor.
Thanks, Don.
Ashley, to clear up the naming for you, Ellie is ELE. That's short for Eleazon, which is Greek for mercy. We've recently, with our pets, gone to more of a faith-based naming system. We also have a brand new rabbit that we got about 6 weeks ago after one passed away. Her name is Verity, which is Latin for truth. But with Io, we were in our geeky naming phase. Our son is a computer geek, and so we kind of went with that. And Io in the computer world is short for input-output, IO. But as well, she kind of has dual namings. She's also named after the moon Io, which orbits Jupiter, and she actually has a lot of similar coloring to what you find on the moon of Io. And Io is actually kind of a violent world. It's very volcanic, and kind of sums up Io's personality sometimes too. So anyways, let's get back to Judge.
Go ahead. Do you mind reaching out to the MAC form, please?
Okay. Judge, going on page.
Mr. Bloomer, come up. Sir.
Come on.
Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer will be appointed to you. Please.
On April 4th, 2025, in Lewis County, Texas, a law enforcement officer was dispatched to a suspicious person call and made contact with the law enforcement officer who stated that he observed the defendant going through a parking garage at Hobby Airport looking into parked cars. The law enforcement officer recognized the defendant as someone who had been trespassed from the airport previously. Defendant did not have a ticket for a flight out of the airport. The prior trespass at the airport was on November 17th, 2024, and was charged in Court 12, Your Honor.
Dismissed.
And be part of the.
Okay, Mr. Bloomer, I'm gonna find that there's probable cause to go forward with the case. Just don't go back to this place, man. It's not hard. You
Yeah, I
know,
go there and I catch my trips and I buy my food, but those people are so crazy. They keep harassing.
they don't want you there, man. Every time you go there, you're gonna get arrested.
Don't do nothing. Why am I not able to go there?
They don't want you to go there.
That's where I catch my flights.
They still have the right to say, we don't want you there. So don't go there. If you have a flight, that's a different story. But if you don't have an actual flight, just don't go.
I'm freely able to come there. Why would somebody tell me I'm not able to come to a public business that I've always been able to come to since a long time ago?
Because if you don't have business there, they
Dude, I
can
always
still,
have business there. I'm not there just going there. I always have business there. I either catch the bus, I go to the food court, or I catch a flight.
Mr. Bloomer, I'm asking you not to go back. There are plenty of other places that you can go to get food, water, clothes, whatever you need.
Okay, and I'm
Don't.
fine with that, but I'm asking, why am I saying that I can't go there?
Because they've trespassed you there before.
And it was
And it-
dismissed. It was no fault.
You listen to me for just 2 seconds. They've trespassed you before, so you know that they don't want you there, number one. Number two, they're saying that you're allegedly looking into cars to potentially breaking into them.
No, sir.
I get it.
I don't
That's why you're not
feel like
charged
it.
with it.
I don't even steal out here. I'm the only guy that spends money some days out here. I've spent more than $1 million in Houston, Texas. I have no reason to steal from anyone. But if you want to check anything you want, I don't steal anything. All my clothes are brand new. Everything I buy is brand new. I have no reason to steal. I catch flights, everything. I've never stolen anything out here in my life. Now, those people, they keep harassing me. That's what I'm telling you. I catch my flights there. I already have a case dismissed there. They will not leave me alone. If I come there and I catch my flight and I sit down, wait for my flight, they'll even walk up to me, watching me on the camera, like, hey, what are you doing here? I'm like, yeah, I'm just catching my flight. And they're like, okay, cool, go ahead. You know what I'm saying? Or then they'll just walk up to me and they'll be like, hey, what are you doing here? I just came from the food court. I'm getting ready to catch my flight. Well, you got to catch your flight right now. If you don't pay for it right now, then you have to leave now. I'm like, why are you going to force me to hurry up and pay? I'm going to pay it right now. I just went and bought my food at the food court. I'm never doing anything there. I'm not a troublemaker here, and I don't need anyone making me seem like a troublemaker. I'm a college student, and I started college at 16, sir.
Please don't go back while this case is over.
Yes, sir.
That's all I'm asking you to do.
Yes, sir.
All right?
Yes, sir.
After the case is done, if you have a flight, then by all means, but I'm going to tell you now,
So,
every time you go back, the same thing is probably going to happen.
yes, sir.
So I'm saying, either go to the other airport, there's 2 other ones that you can go to, or find another way.
Thank you so much.
Every time you go there, the same thing is going to happen.
Yes, sir.
So why let it happen?
Yes, sir. I just didn't know. The only reason why I went back the second time is because the first time was.
No, I don't want you to say something that hurts your case. Don't.
Yes, sir.
I will give you a lawyer now. You can talk to the lawyer and we can figure out where to go from here.
Yes, sir.
I'm gonna have bond conditions created just for you to sign, promising us you're not gonna go back. And after that, I'll let you talk to the lawyer and then you guys figure out how we go from here. Just don't go back.
But thank
You know, there's so many other places in the world that you can go to. If you go back, this is gonna continue to happen.
Yes,
I
sir.
know you have better stuff to do than to come here.
Yes, sir.
You know, I do too. They force me to come here. All right, ready?
Yes, sir.
That way.
Thank you.
Can you file that, please? Was it Hobby?
Is it just me or was that one weird? So he just started college. He's spent over $1 million in the city of Houston as proof, I guess, that he doesn't take things, but yet he's being given a lawyer? I don't know. That one's confusing to me. If you have a different thought on the matter, please put it in the chat. Let's keep rolling with Judge. See if his morning continues to be busy.
States.
Let's go with.
Carlton, Patrick Carlton, page 3, Jeff.
Okay, and go ahead, reach out. Okay. Morning, Mr. Carlton. Morning. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On April 5th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a person down call and made contact with a real witness, a law enforcement officer who stated that they found the defendant asleep behind the wheel of a vehicle that had rolled onto the median of the road. The vehicle was running but not moving when they found the vehicle. The real witness woke the defendant up and placed the defendant in the back of their patrol car. I should specify the real witness was the law enforcement officer. Law enforcement officer made contact with the defendant, who was slurring his words and had dilated pupils. The defendant admitted to drinking 2 beers at a restaurant, and defendant was presented with a DIC form but refused to sign it. Standardized sobriety test was later conducted, and the law enforcement officer observed 6 out of 6 clues on the HGN, 4 out of 8 on the walking turn, and 0 out of 4 on the one-leg stand. The defendant eventually consented to a breath test in blue 0.063 and 0.064.
Mr. Carlton, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you see if he has any prior DWIs? And then if he has a valid license, please.
Yes. His license is not eligible, Your Honor, and no prior age.
Okay. You're not allowed to drive. I don't care what you have to do in this life. I don't care if there's a burning building and you have to say 50 kids, do not drive. Do you understand?
Yes, sir.
You will be signing an affidavit with me today. This is a promise you're going to make to me. You can't justify getting into a car for any reason. If you do, I can have a contempt hearing. You could be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer, Mr. Carlton? Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we're going to give you time to go hire a lawyer. I will have you first come up here, swear to us that you're not going to drive. I will get you to Ramona, where we will have you sign a reset. You will get with Felicia for your bond condition, where you promise us you're not going to use.
Sure.
Don't pick up any new cases. Don't be a danger to my city. Do you understand?
Sure.
Okay,
Gotcha.
come on. Yeah.
Bobby Parnell, page 3.
Good morning, Mr. Carnell. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On April 4th, 2025, in Harris County, Texas, a law enforcement officer was at a red light and saw a car run a red light going the other direction. The law enforcement officer initiated a traffic stop and observed slurred speech and the odor of alcoholic beverage from the defendant. The defendant then told the law enforcement officer, "I'm sorry, I'm drunk." The defendant admitted to consuming 4 beers prior to driving. The defendant got out of the car, and the law enforcement officer observed the defendant to have slurred speech, a swaying stance, a staggered stride, and the odor of an alcoholic beverage. When the law enforcement officer instructed the defendant to stand in front of the law enforcement officer's vehicle, the defendant said, "I can't." The defendant then again said he had been drinking and then admitted that he had 10 beers at a bar. The standardized sobriety tests were conducted. The officer witnessed 2 out of 6 clues on the HGN test, The defendant could not stay focused and could not complete the entire test. The defendant then lost his balance and refused the other two standardized field sobriety tests, and then refused to provide a specimen. A blood warrant was obtained and executed.
See, any priors?
No prior DWIs, Your Honor, and his license is eligible.
Mr. Carnell, I'm going to find that there's a problem, or that there's enough probable cause to go forward with your case. If you have a problem with drugs or alcohol,
I have none.
you better address it, because if you don't, and I see that it becomes a problem, we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand? I'm warning you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. And I'm telling you now that I'm going to test you. If I find that you're using, I will put you in jail. Do you understand?
So,
You have the ability to hire a lawyer.
no, sir. No.
I can have you fill out an application. Deputy Miranda will give you an application. I'll look to see whether you qualify. I need to know everything about you. What kind of job you have, what kind of money you have, money in the bank, stocks, bonds, mutual funds, IRAs, and a car you drive, and I'll take a look to see whether you qualify.
Okay.
Okay? Deputy Miranda will give you an application. I'll have you sign a receipt with Ramona. You'll get with police if your bond conditions, and then we'll have you take a seat in the jury box.
No, I'm sorry, sir.
They'll help you. And
Judge, Justin Castro is next.
Justin Castro, come up. Yes.
Judge. Did you want to? Oh, no, you know.
Speak English, sir.
Yes, English.
Mr. Castro, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 3rd, 2025, in Harris County, Texas, a law enforcement officer computed information about a computer takeover event and went to the location that was put on social media. The law enforcement officers conducted surveillance on the location in an unmarked vehicle and witnessed a vehicle making donuts and get within close proximity of several parked occupied vehicles. Law enforcement officer initiated a traffic stop on the vehicle and detained the defendant, the driver of the vehicle making donuts.
Any prior reckless driving cases, and then can you see if he has a license, please?
There are no prior reckless driving cases, Judge. There was a DWI and evading vehicle out of Dalton County. Just
At Hidalgo?
additional.
Okay. Anything else?
And driver.
Okay. Mr. Castro, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now not to participate in this activity anymore or drive recklessly, maniacally. If I find that you do, the first thing I'm going to do is put you in jail. And the next thing is I will take your ability to drive away from you while this case is open. Do you understand?
Yes, sir.
Living in a city as big as Houston without the ability to drive blows. Not only that, people who participate in these types of activities, cops and DA's office can seize and take your car away from you permanently. And I've seen it happen on multiple occasions where people lose their $100,000 car because they. Do you understand?
Sir.
You put bond conditions, no donuts, street takeovers, reckless driving, racing, et cetera, please. Mr. Castro, do you have the ability to hire a lawyer?
Yes.
We're going to give you time. So I'll have you go to Ramona, sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign the bond conditions. After that, we'll let you go. When you come back, please have a lawyer.
Judge, I apologize. Did you say no driving or just no
No,
reckless?
no reckless driving, donuts, street takeovers, racing. And all that. I am.
Philip Pointing, page 5.
So we'll go ahead and continue to ride with Judge Fleischer for a little while. Number one, he's entertaining. Number two, Fridays are usually busy, so let's at least ride with him through his arraignments.
Good morning, Mr. De La Puente. You're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 5th, 2025, in Harris County, Texas, a law enforcement officer observed vehicles going to a Home Depot parking lot to take part in a street takeover. Law enforcement officers witnessed the vehicle do donuts and come within 5 to 7 feet of other occupied vehicles and nearly strike the people sitting in those vehicles. The law enforcement officer initiated a traffic stop and detained the defendant, the driver of the vehicle, doing this.
Did you hear everything I just told the last gentleman? Same thing applies to you. Or does he have a license?
Yes, Your Honor.
Prior reckless driving?
No, Your Honor.
If I find that you participate in this again, I'm gonna put you in jail, number one, and then I will take your ability to drive away from you. Do you understand?
Yes, sir.
No more of this. Don't drive maniacally. We have enough death and destruction on our streets as it is.
Sure.
Can you file the exact same condition, please?
Yes, Your Honor.
Mr. De La Fuente, do you have the ability to hire a lawyer?
Yes, sir. I do.
We're gonna give you time, so I will have you sign a receipt with Victoria, with Ramona. We'll have you take the seat in the jury box till we get your bond condition. We'll have you sign it, and after that, you'll be free to go. Please. Hi.
Good morning, Judge.
Hi.
How are you doing?
Good. Good morning. Happy Friday.
Happy Friday.
What's up?
Today's a lot calmer than the other Fridays, so I'm happy about it
For now.
for now. I have Jose Estrada on the docket.
Okay.
He has 2 cases. He just posted bond last week. We just had this case, so I would ask for a reset so we can have more time to receive the evidence.
This way we can get all questions, Judge.
I'm bringing them up, please.
Mr. Estrada?
You're not to consume alcohol or illegal drugs. I'm gonna test you like crazy. If I find that you're using, I'm gonna double, if not triple, everything else. Do you understand?
Yes, sir.
Does he have a license? You mind checking, please?
He's driven his last year.
Your Honor, this is a different one. I believe it was the wrong driver's license number that was run.
If you don't have a license and insurance in your name, you're not allowed to drive. Do you understand? I don't know whether you do or not. And quite frankly, it's on you to know whether you do or not. If you don't know, then you need to call DPS and figure out. If you don't have a license, if you don't have insurance in your name, do not drive. That is also a condition. Do you understand?
Sir.
You pick up a third case, I'm gonna freaking lose it. Behave yourself while you're out in the free world, or I'm gonna take the free world away from you. Okay? He needs to sign conditions with police. All right.
Just trying.
Your Honor, I apologize. I was able to find his driver's license number open a couple of cross
Yeah,
checks.
so he does have one? Okay, good.
Okay, really quick while he's between things, I wanted to show you guys something up on your screen. There is a screenshot of a poll that I started yesterday in the post tab of the Courtroom Files YouTube channel page. And we've had a couple of regular videos that I've posted where we've had rather emotional victim impact statements that, on the surface anyways, appeared to influence the final decision of the judge. So I put out there, should a judge allow emotion to affect his or her rulings or sentencing? And the results are fascinating for me so far. So we have 240 some odd votes. 42% of respondents are either in the yes, emotional impact matters, or maybe depends on the situation column. So almost half of respondents so far are saying that emotion should play a role in how justice is administered. I find that fascinating. I'm not sure what I think of that yet. I'm still processing it. But I point it out because it's curious. Does that surprise you, or does it just surprise me? Let me know your thoughts on it. If you haven't taken part in the poll, feel free. Again, it's on the channel page. It just wasn't necessarily the result I was expecting, so it's curiosity. Anyways, let's go back to Judge.
Itavard on page 7.
Itavard, come up. I chatted you, Mr. Tyser. Chat me what you got real quick. Good morning, Ms. Itavard.
Good morning.
Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Actually, probable cause has already been found in your case. So, I'm ordering you now as a condition of your bond not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes.
There's nothing that you can do in this life that would justify getting into a car without having both of those documents.
Yes, sir.
You will go to jail if you do. Do you understand?
Yeah.
Do you have the ability to hire a lawyer, man?
Not right now.
Okay, I can have you fill out an application. I'll take a look to see whether you qualify. I don't know. We don't just give out lawyers like it's candy. So you have to qualify. We'll have you fill out an application. I need to know everything about you, how much money you make, what kind of cars you have, stocks, bonds, mutual funds, IRAs, and then we'll take a look. Deputy Miranda's going to give you an application. I'll have you sign a receipt with Ramona, and then I need you to sign this affidavit promising us you're not going to drive. Come on.
Judge, you want to follow the violations?
Please. No driving without both. Yeah. Bring it.
Diaz on page 5. Kevin Diaz.
Oh. Right here. You are on per case and you've now picked up a new case. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yeah, just one moment. Your Honor, on April 30, 2025, in Harris County, Texas, law enforcement officer observed a vehicle fail to signal and turn into a private driveway and initiated a traffic stop. Upon approaching the vehicle, the defendant, who was sitting in the passenger seat, could not roll down the window, and the defendant and the driver were detained for officer safety due to this issue. When the vehicle door was opened, the law enforcement officer observed the strong odor of marijuana and carried out a probable cause search. Law enforcement officer located marijuana on the front passenger floorboard in a pocket satchel where the defendant was sitting. The defendant admitted to the marijuana being his. Law enforcement officer also found a large amount of small baggies of marijuana, a small scale in the driver door pocket, and a vacuum seal bag in the back seat with marijuana shake in it. The total weight of the marijuana found was 4.91 grams.
Mr. Diaz, I'm going to find that there's probable cause to go forward with the case, and I am now revoking your bond on the first case. I told you not to pick up any new case. You've now picked up a new case. It goes with you.
Can I speak?
I'm gonna get you a lawyer. Don't worry.
Going to work and I wasn't even driving shit.
Don't pick up new cases.
Which one was this last time?
That's page 5.
About
Page 5. Oh, you don't know Diaz. He has a phone bond for theft. So on that theft, 5,001, please.
Barbara, you've been with us almost since the start of the live show, and thank you. Thank you so much for becoming a channel member. Again, anybody who becomes a channel member, it's $2.99 a month. Doesn't cost you a ton. Goes a long way towards supporting the channel. We're gonna, the back half of this month, really focus on building out our members-only content, so there'll be more for you there. And I mentioned this yesterday, but it will be fact within probably a week or two. We're going to get to the point, just because of the growth of the channel, and I don't have a choice, where channel members are going to be the only ones who are guaranteed to get their comments read in videos and their comments replied to in videos. I'll always be active in the chat on the live, but for the most part, I'm going to have to abandon the comments section of our regular videos because it's becoming a full-time job in and of itself, and it becomes a matter of, do I spend that time making content or responding to people? Well, I'm going to make content because that's what you guys are here for. But again, Barbara, thank you. I really appreciate your support. Again, you've been with us almost since the start of the live, and it means a lot, so thank you.
County, Texas, officers were dispatched to a disturbance call. The officer met with the complaining witness who stated that the defendant is from roommate. The complaining witness stated that they got into an argument over a broom and the defendant struck her on the head with the broom, causing pain. The officer observed a raised bump on the complaining witness's head that was starting to become discolored.
Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to have any contact with this complaining witness. You're also ordered not to be in possession of weapons. If you violate this order, I'm going to put you in jail. No more PR bonds. Do you understand, ma'am?
No, sir.
There is.
Was that it, Sarah?
Thank you.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they can file additional charges against you, a violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? It's one of the worst cases you can pick up. So don't violate the protective order.
Okay, yes, sir.
Okay. Would you like, do you have the ability to hire a lawyer?
No.
Okay. I can appoint you a lawyer to, or I can have you fill out an application. Let me see if you filled one out first. Hold on. I have an application on file already. I have one on file. So what I can do is I can appoint you a lawyer today. We're going to create bond conditions for you. Do not leave until you sign those bond conditions. Otherwise, I'll issue a warrant. The bond conditions, no contact, no weapons.
Okay.
All right. For now, I'll have you go to Ramona, sign a reset, and then we'll have you take your seat in the jury box.
Okay.
Please.
You're gonna leave it.
The Kaz man, thank you for becoming a channel member. You're all being really good to me today. I appreciate it. You know, $2.99 doesn't sound like a lot, but I live in this world right now too, and $2.99 is a lot. So it means a lot, seriously. My real hope with starting this live was to build a cohesive community that could come together every day and interact, and talk about the law and talk about our lives and have some fun, but not have all of the stresses of the world and politics and everything else. And that's really starting to come to fruition, and I appreciate it. So again, the cast man, thank you.
So just chat me your phone number and then I'll get a hold of you later. Okay?
I just sent it. Thanks, Your Honor.
This is Mr. Jones.
Yes, Judge.
Is Joseph Jones?
Yes.
Okay, Mr. Jones, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 6, 2025, in Harris County, Texas, law enforcement officers took a vehicle with expired registration and initiated a traffic stop. Upon contact with the defendant, the law enforcement officer observed strongly with marijuana. The defendant informed the officer there was a gun in the passenger compartment. The probable cause search revealed the gun to be unholstered in the passenger compartment within arm's reach, and a clear plastic bag containing marijuana in the center console.
All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. I'm not putting any conditions on your bond. The only thing is, can you look to see if he has a license, please?
Yes, Your Honor.
Do not drive unless you have a valid Texas driver license and liability insurance. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Said it, yeah.
You have the ability to hire a lawyer.
Yeah, but I didn't,
No, I don't want to talk about the case.
Oh.
You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're going to sit there and type and use it against you. So just don't.
all right,
You'll have the ability to fight the case. Now's not the time. Do you have the ability to hire a lawyer?
no,
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. What kind of job, what kind of car, how much money in the bank you have, stocks, bonds, everything about you, and I'll take a look to see if you qualify. Deputy Miranda will give you an application. I'll have you sign a receipt with Ramona, and then we'll have you take a signature box.
He has a valid license.
Great.
In your streets of sound.
Okay.
Mr. Goodwin,
Mr. Manier.
Bloomer?
Hey, hi. Happy Friday.
Happy Friday. I've just got one. It should be a quick reset. It's a Mr. Johnson. He failed to report for a drug test. Pre-trial spoken with him. It just wasn't communicated to him. So
Has he gone to test?
I sent him this morning, Judge. He was negative.
Yes, Your Honor.
Where are we with it regardless?
We're applying for PTI. He literally gave me the packet today.
Okay. So do you have everything that you need? Because it's 180 days. Because he give you.
Yes. So he is below a 0.15. I don't think he'll need a mitigation packet, so I should be able to turn this in with a non-driving affidavit, and we should be done.
I'll take about 2 weeks.
Sounds good, Judge.
Setting so we know yay or nay, and then send him for.
I like this plan. And do y'all have a non-driving affidavit?
Shatori can give you the one that you need, and then that'll work. Because that's the actual one that I think that they need. So,
Thank you, Judge.
okay, thanks.
Eric Johnson. Wayne.
No, must appear.
I think he's going over.
So as much as I like to flip around, we will continue with Judge Fleischer for a little bit, because literally every court I'm looking at is now in recess, except for him. So it's Fleischer, so we're going to ride with Fleischer.
To the best of your knowledge. Thank you for that. A seat.
Other way around. Other way. So,
Guys, when you come, go that way. We don't want you near the prosecutor. That way. All right. You are Mr. Coombs.
Yes.
Mr. Coombs, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge. On April 5th, 2025, in Harris County, Texas, the law enforcement officer saw a truck fail to signal in the left turn and drive on the wrong side of the road. Law enforcement officer initiated a traffic stop and made contact with the defendant.
Hicieron contacto
Law
con el
enforcement officer
acusado.
observed signs of intoxication and called for a second law enforcement officer to
Llamó
conduct a
al
DWI
segundo
investigation.
oficial para que le
That
hiciera
law enforcement
pruebas de
officer
campo.
observed red, watery, bloodshot eyes,
Observó los ojos rojizos,
strong odor of alcohol,
un fuerte olor de
poor
bebida
balance, and
alcohólica,
slurred speech.
poco
Law enforcement officer placed the
equilibrio
defendant
y
in
el
custody
habla
and searched the defendant's vehicle,
afectada.
revealing a
Hicieron,
phone
I'm
copy.
sorry, can you repeat that?
The law enforcement officer
El
placed the
oficial de
defendant
policía
in
puso la
custody
acusada bajo
and a search of
custodia
the defendant's
y de un
vehicle
registro
revealed
del
a phone
vehículo,
cuff and
no
alcoholic
una
beverages.
bebida alcohólica.
Standardized field sobriety
Hicieron las
tests
pruebas de campo
were conducted,
y
and the law enforcement
el
officer
oficial de
observed 6
policía
out of 6
observó 6
clues
de
on the
11
HGM
pistas
test,
del
4 out of 8 on the
4 de un
walk
golpe
and
de
turn, and
caminar
3
y
out of 4
voltear
on
y
one
2
leg
de un
stand.
4 de parar en una
The
pierna.
defendant refused to provide a
El
specimen,
acusado
and the blood
rehusó
warrant was
dar una
obtained and
prueba, le
executed.
hicieron
Since 2017, DWI, assault,
agresión.
late last year evading arrest in a motor vehicle, and now another DWI.
Otro. Jarebe.
If you are not in this country with permission and you go to jail, what happens?
¿Qué sucede?
Mr. Coombs.
Mr. Coombs.
No, no deportó.
They will deport me.
Right. I don't know what I need to do to
Okay.
keep my streets safe. But if I find that you, one iota, do anything to break these bond conditions, I'm going to make your bond so high you will have hair falling out. Do you understand?
¿Lo entiende?
I would figure that it's elementary that you're not to have alcohol in the car while you drive.
Alcohol.
I am now taking away your privilege to drive, and you will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, I will blow a gasket. I can have a contempt hearing, and every time you drive, you can be facing an additional 6 months in jail and a $500 fine. Do you understand?
Entiende. I understand.
Not to
Se le
consume
ordena que no consuma
illegal drugs.
o drogas.
On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol.
Asegurarle que usted no-
On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I do not want you out in the middle of the night. And if I find that, like I
de
said,
la calle,
any
en medio de la noche, perdón.
of these conditions are broken,
Cualquiera de
into
estas
jail you will go
a la
with a
cárcel.
bond that will hit the nubes.
I understand.
I am sending notice to DPS now that I am placing a restriction on you that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. Every single officer in this state will know that if you get pulled over and you don't have an interlock, into jail you will go. Because the document we're sending now to DPS notifies every officer that you're not allowed to drive without an ignition interlock in the car. Do you
Lo
understand?
entiende. I understand.
The worst possible thing you can do in the short life that we have, Mr. Coombs, is get into a car and drive.
Meterse en un carro y manejar. I understand.
Judge, what was the curfew?
9 to 6.
9, 6.
You're ordered not to consume alcohol, illegal drugs, unprescribed controlled medication.
Medicamentos no
You will be
recetados.
randomly tested. If you test positive for drugs, alcohol, your bond will be revoked. You will go into custody.
Revocará.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Newling. If he tells me that he cannot get a hold of you, if you pick up a new case, if you become a danger to my city, you know what happens.
Sabe lo que va a suceder.
Do you understand?
¿Te lo entiende? I understand.
What's your name? That's the showing name. So, Mr. Is it Combs? Raise your right hand for me. You stand swear on your own keys, that you will not operate in your vehicle. For you to live in a will that have all driver's license, permission from the court, that you on the court, or police interrupt device, or that not a vehicle.
Judge Jones on, page 10.
Marquise Jones, come up. Good morning, Mr. Jones. Sir, you're charged with driving while your license is suspended, second offense. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Okay. Thank you, ma'am. I'm sorry, so.
Mr. Della Fuente?
Judge, on April 4th, 2025, in Harris County, Texas, law enforcement officer observed a vehicle traveling 85 miles an hour in a 65-mile-an-hour zone and to have unconfirmed insurance status. The traffic stop was initiated and the defendant was unable to provide proof of insurance. A check on the defendant's license found that the defendant was not eligible to hold a license and that he had previously been convicted of driving while license invalid.
Okay. Mr. Jones, I'm ordering you as a condition of your bond not to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. There's nothing that you can justify getting in a car and driving. If you do, there will be a heavy and severe penalty. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine on a contempt every time you drive. Do you understand? Sir. This is a super easy solution. If you want to drive, go to DPS, get your license, get insurance, and I will do backflips taking this off. But until that point, if you do this, it's really not going to go well for you. Do you have the ability to hire a lawyer? I can give you an application and take a look to see whether you qualify. Deputy Miranda will give you an application. I need to know everything about you. And then I'll take a look to see whether you qualify. Don't just put zeros because I'm going to give it right back to you. Do you understand? Okay, please. He needs to sign this affidavit there as well. Okay, you ready? Come on.
Judge, we're on Chloe Serrano.
An S, right?
Yes, Your Honor.
Do you mind bringing him up?
Chloe, come on up, please.
Page 17.
Thanks.
We don't mind waiving probable cause. It's a red light, 0.14.
I'd like to know though.
Okay, sure. Both.
Good morning, Ms. Serrano. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On April 6th, 2025, in Harris County, Texas, law enforcement officer witnessed a vehicle running a red light and conducted a traffic stop. The officer observed the defendant operating the vehicle, and upon contact with the defendant, observed the mild odor of an alcoholic beverage from the defendant's breath, slurred speech, and glossy eye. The defendant admitted drinking 3 alcoholic beverages prior to driving. The officer observed an open container of a bottle of Cayman Jack margarita.
Are you telling me that she's consuming alcohol while she's driving?
That is. No. No, Your Honor, I apologize. It was on the back floor behind the driver's. It was an empty bottle. Sorry, I don't know if I can specify, the defendant admitted drinking 3 beers, that became a Jack Margarita at her residence prior to driving the vehicle, and that, and the one open attendant inside the vehicle that just empty bottle on the back.
Okay. So field sobriety test.
Yes, Your Honor, I apologize, I'm sorry. The defendant consented to the field sobriety test, and witnessed 406 cruising the HGN, 708 from walk turn, and 404 in one lane. The defendant consented to a breath test and the .142.
Okay. Ms. Serrano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well. Do you understand? Because you have a lawyer, I will waive your appearance, but you must stay in touch with them and they'll tell you if and when you have to come back to court. When I find that people have alcohol in the car while they're driving, it's elementary that you're not. You understand? Don't use, don't pick up any new cases, and don't be endangered in my city. You understand? Okay, I'll have you sign a reset with Ramona. We'll have you get with Fleischer for your bond conditions. Thank you. There you go.
Thank you, Your Honor.
Oh, there's my volume. Okay, let's talk about that, Aunt Jemima. He doesn't really threaten deportation as much as it's a warning, but you, and your question is, well, why aren't they just getting deported? Well, it becomes honestly kind of a matter of jurisdiction. A judge can try what's in front of him. So he's talking to the charges that that person has been charged with and then have been presented to him to proceed with. Unless there is an outstanding warrant for that person's arrest for a deportation issue, he doesn't have the authority to just grab them and say, you're in the country illegally, off you go. But he does warn people if they spend any time in the jail, ICE sweeps the jails every few hours, figures out who's there, who isn't in the country legally, and then they'll get a detainer placed on them. And when that case is done, they'll go to ICE for their fun. So that's kind of why that happens. A lot of people I've found, the more and more we get into things here at the Courtroom Files and read through the comments and watch how people react, there's a lot of belief that judges, well, why don't judges do this or why don't judges do that? For the most part, again, the only thing they can deal with is what's in front of them, what's been presented to them within the 4 corners of the charging document. There are some exceptions, like with contempt, for example. The judge has some power to initiate a fine, put some person in jail, something like that. But other than that, it's within the 4 corners of the charging document that they have to work with. So hopefully that clears that up. And somebody else had something. Oh, yeah, Linkman. Big guy, even I wouldn't drink 3 before driving. She's tiny. Funny, Mrs. The Courtroom Files is a very tiny woman. And she could drink me under the table on a good night. It's all in how you process it. She and I don't really drink anymore. We had a glass of wine for our anniversary the other day, and we both left with a headache from that. We're too old to play that game. But yeah, never judge a book, man. All right, back to Judge.
Your Honor,
Correct.
So is it,
it was just a project.
Yeah, someone.
stop. Don't. No. Do you have the ability to hire a lawyer? So I can have you fill out an application. I'll take a look to see whether you qualify. Do not have any contact with the complaining witness in this case. Don't pick up any new cases. It's not going to go well for you. Do you understand?
I'm kidding you. This is crazy.
So he needs state's bond conditions. I'm going to give him an application.
I've run this
So
3 times.
filing those conditions.
Yes, sir.
Jesus.
So I'm going to give you an application. We need you to sign a reset and then take a seat from the jury box.
Your Honor, it was offense location. Is that right?
Oh, no. You're right. You're right. I got one. Don't worry about it. I have one.
Just make sure, Your Honor, it's offense location. Was that?
Check with the complaining witness. We're going back to this check cashing place. It's
on the. So let's dispose.
Ashley Salas, come up. Salas.
People were named.
And you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Oh, goodness. You're charged with driving while intoxicated, possession of marijuana, and harassment of a public servant. On the DWI, you're facing up to 6 months in jail and or 2,000. Are you high right now?
What? Like, what'd you say?
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, man. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Oh,
On April 6, 2025, a traffic stop was conducted for the defense vehicle failing to maintain a single lane, following too closely. The defendant captured a pit stop at a flashing red light intersection. The officer, on contact with the defendant, the officer observed the driver and passenger to make further movements towards the center of the vehicle. The defendant was identified by extra driver's license. The officer observed slurred speech and bloodshot watery eyes. No alcoholic beverage was emitting from the defendant's breath, and the strong of marijuana was being. The defendant admitted to having marijuana in the vehicle, and the officer located a leafy substance in the console of the vehicle upon probable. The officer also observed an open beer in the motor vehicle and another Ziploc bag with large amounts of marijuana. The officer also observed a Ziploc bag of narcotic mushrooms and a scale with marijuana residue on the surface located next to a large stack of other Ziploc bags. The defendant had $274 in cash. The defendant claimed ownership of the narcotics in the bag as well, and admitted that the items were marijuana and
Psilocybin,
excuse
the
me.
mushrooms.
Yes, sir. The defendant stated that she drank one margarita and that she also smoked marijuana. Certain field sobriety tests were conducted, and the officer observed 4 to 6 clues on the HGN, 4 to 8 on the walking turn, and 2 to 4 on the one leg stand. The defendant refused to provide a blood specimen. A search warrant was obtained. The defendant flailed and resisted during the blood draw. The defendant continued to flail and spit on officers and was eventually transferred to a hospital. Blood draw was unsuccessful due to the defendant flailing. Finally, there's another attempt and the blood draw was successful.
Salas, I'm going to find that there's probable cause to go forward with your case. If you have a problem with drugs or alcohol, you better address it, because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
yeah.
I'm sending you for a test right now, and you're to come right back. Do you understand? If you fail to take the test, if you fail to come back, a warrant will issue. Do you understand?
So you want me to take a test right now?
Right
Yeah.
now.
It's not gonna come
Stop.
out clean.
I want to know what, if anything, is in your system. Come back, and then we'll talk further. I'm going to appoint you a lawyer today. Take the test, come back. You understand?
Okay.
You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to tell you now, I'm going to test you like crazy. Do you understand? If you use after today, it's not going to go well. As far as the marijuana is concerned, I'm going to test you like 50 days from today to ensure there's enough time for it to pass. If you continue to test positive, do you understand?
Yeah.
I'm giving you the opportunity now to stop on your own. If you're unable to, that's when things will go sideways real quick. Does she have a valid license? And then any prior DWIs as well?
It's a true first and her license is valid.
Okay, all right. So for now, I'm gonna have you sign a reset with Ramona. I'm gonna have you get with Fleischer, and I'll see you in about half an hour. Please.
Well, you've got to admire her honesty, I suppose. Like, it's not going to come back well. You're kidding. We had no idea. So yeah, if she shows back up during the live, that'll be interesting. If not, if she shows up during the docket, but we're not live, I'll probably post a video on it this weekend just to update. I'm going to continue with Judge Fleischer because, again, all the other courtrooms I'm monitoring, they're either already done for the day or they're in recess. The only exception at the moment is Judge Meineke, but he's out in his courtroom and his audio is atrocious to the point where I can't do anything with it. So it makes no sense. I do have something queued up if it gets boring here that we can switch to, though.
House?
It's been a while since I've been in there, so. Well,
Don't come in shorts again, otherwise I will put you out.
yes, sir. I
Understand?
apologize. Yes,
It's
sir.
a complete sign of disrespect.
I
There's a
didn't-
certain dress code that we have here. You now stand charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Ask who the accuser is.
Stop.
Please, sir.
Didn't ask you to say anything. We're gonna do probable cause. I need to know what happened in this case.
All right.
On November 10th, 2024, at approximately 6:19 p.m., a law enforcement officer was dispatched to a suspicious person call at Halcyon Games in Orange County, Texas. Law enforcement officer made contact with the complaining witness, the store manager. Complaining witness called police regarding the defendant who came to the store and intended to sell a previously stolen item from the same store. The manager could not prove the item brought to the store was the actual item intended to sell. Complaining witness called the law enforcement officer and the was gone upon their arrival. Approximately 2 p.m., the complaining witness from surveillance video, the defendant inside the store and appeared to be shopping. The defendant then took and concealed 2 MTG booster boxes inside a shoulder bag on the defendant's person. The defendant passed all points of sale without showing any intention to pay for the items. The total value of the items was $599.99. This was from a game store owner, Halcyon Games.
Mr. Sandwick, I'm gonna find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to go back to this place. Do you understand?
Yes, sir.
If I find that you go back to this place, if I find that you pick up a new case, if you miss court again, a warrant will issue. No more PR bonds for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, I can.
Okay, we're gonna give you time. So I will have you go to Ramona, sign a reset. I'm gonna have you take a seat in the jury box. So we'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go.
Thank you, sir. I apologize for the short.
That's all right. Just please. Wait. Can you file this condition, please?
Yeah, sure. There's just to stay away from the store. Right?
Yeah.
On page 17, Jared. Yours.
Saeed, come up.
Good morning, sir.
Good morning, sir. Sir, you are Saeed, is it Saeed?
Say yeah.
Saeed. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On April 5th, 2025, in Harris County, Texas, officers observed the defense vehicle going 105 miles an hour on the Northwest Freeway in a 60-mile-an-hour zone. The traffic stop was initiated, and the officer observed the defendant to be the driver and the sole occupant. The defendant was identified by a German identification card. Officer observed bloodshot eyes, slurred speech, and a strong odor of an alcoholic beverage from the defendant. The defendant stated he would not answer questions and would not perform standardized fit sobriety tests. A breath test was refused, and the officer observed 3 empty beer bottles and an empty bottle of wine in the defendant's motor vehicle. A blood warrant was obtained and a blood draw was executed.
Are you trying to tell me that he's consuming while driving?
Just have a moment, Your Honor. Does not specify, Your Honor.
Regardless, Mr. Said, you are not allowed to drive unless you have a valid license to drive. You understand? All I heard here was a German identification card. If you do not have a license to drive and liability insurance in your name, then you're not allowed to drive, and that is a condition of your bond. If I find that you violate these conditions, then I'm going to put you in jail. No more PR bond. Do you understand?
Yes, Your Honor.
I'm also ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, into jail you will go. No more PR bonds.
Yes, Your Honor.
I don't know what your immigration status is, but if you're not in this country with permission, if your paperwork is not done the right way and you go to jail and immigration finds you, they will put an immigration detainer and you will be stuck like Chuck in there until this case is over with, which could be 6 months, and then you get shipped off to immigration. You understand?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer?
No, Your Honor, I'm not allowed to work right now.
Okay, I can have you fill out an application. I need to know everything about you, how much money you have at the bank, how you get money, how kind of cars you have, property, stocks, bonds, mutual funds, IRAs. I'll take a look to see whether you qualify, and then we'll go from there. We'll have you give you an application. I'll have you sign a reset with Ramona, and then we'll have you take your signature box.
You said no driving?
Unless, does he have any kind of,
From what I have, Your Honor, he does not have a license.
I do have a license.
we'll,
Without insurance and.
with the no driving without a valid license and insurance? Okay, all right. Any prior DWIs?
Judge Ring.
Yeah.
White on page 21.
Lauren. Walter White, come up. Good morning, Mr. White. You were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On April 5th, 2025, in Harris County, Texas, officer was dispatched in reference to a minor accident call. An officer contacted the defendant who was standing next to his motor vehicle. When the officer arrived, the defendant stated he drank a total of 5 beers that day. The defendant stated he last drank 30 minutes before the accident. Strong odor of an alcoholic beverage was emitting from the vehicle, and the defendant was transported to the hospital to treat injuries. The defendant was stated he was scared to blow and failed the test. DSC was read, and the defendant eventually submitted to the breath test and blew .091.
So there's an accident.
Yes, Your Honor.
I guess they took him to the hospital. They didn't do field to ride tests. I mean, it just,
Yes, Your Honor. If I just at the moment, I'm trying to clear by here in the dens.
don't, please.
An accident, the officers find the defendant standing outside of the truck.
Alone?
So, Your Honor, and then stated he was following someone and looking at his GPS because he wasn't familiar with the area and was unaware that cars were parked on the side of the street. The defendant said that he had been drinking throughout the day. Total of 5 beers, and the last one was 30 minutes prior. Officers observed a strong odor of alcoholic beverages from the vehicle. EMS was called to the scene because the defendant had a gash on his chin. He was then transported to the hospital to be checked out. After being released from the hospital, the officers asked him to consent to a breath test. And the defendant said he was scared to blow because he knows he just finished a beer and knew he was going to fail the test. The defendant then agreed to blowing once they got to JPC and the defendant.
So they took him directly from the hospital to the JPC?
Correct, Your Honor.
Mhm. Okay. Mr. White, I'm going to find that there's sufficient probable cause to go forward with your case. Do not consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, it's not going to go well. Do you understand?
Yes, sir.
Can you prior DWIs and a license, please?
Yes, Your Honor.
It's a true first and the license is eligible.
Great. Unless you have liability insurance in your name as well, you're not allowed to drive. Do you understand? Do you have the ability to hire a lawyer, sir?
I'm not sure yet. I can make a phone call and see if he'll take my case. If not, I'm gonna need a court
Look,
appointment.
I can give you time. Just, time is of the essence. This is the DWI, so don't sit there and wait a month, 2 months, because you're only hurting yourself.
I can go make the phone call right now.
No. Don't do anything. I will give you time. You don't need to run out, rush now, but I'm saying don't sit there, wait a week or two, because you're only hurting yourself. So, what I can have you do is sign a reset with Ramona. I'll have you get Fleischer for your bond conditions. After that, you're free to go. Don't use. Do you understand?
Yeah, so if I understand, you're just gonna reset it and that's gonna give me time to either get a lawyer or y'all gonna appoint one?
Right, so.
I'll have to come
go out
back and do
there,
the same
see-
thing I'm doing now?
Have trouble, come back in the next setting and then we can talk.
Come back in the next.
The next reset date, yeah.
set. Okay, so I will have to come
We're
back
gonna
to
give you
court.
30 days from today. So we're gonna give you a lot of time. If you still have issues, come back and we can
I
talk.
was just kind of hoping I have to come back to court.
I wish I had hair. That ain't gonna happen. Well, maybe I get an implant.
Judge Woodall is the next one.
Jimmy.
So yes, Barbara Keen-Eye, co-host Ellie, has entered the studio. She's a little bit surly with me at the moment, though, because she came into the studio and then immediately took a seat on the access point for the network, which she could easily... Yeah, you were going there again. You can easily knock out the stream, and then these poor people won't have anything to watch, and they'll be sad. So you have to be careful where you sit, sweetheart.
You're now working 1, 2, 3, 4, 5, 6, 7, 8, 9. It is your 10th case. You know, when you come to court, you don't come in shorts. So, am I right? It's a complete sign of disrespect, Mr. Woodall. You're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On April 4, 2025, in Harris County, Texas, law enforcement officer was dispatched to his supposed call at a convenience store. Finding witness informed the officers that the defendant had returned to the store after a verbal criminal trespass warning from the complaining witness and a deputy. The defendant returned and picked up an object and threw it on the store's roof, and then entered the store and stated he was going to bust CW up. Bust the complaining witness out. I apologize. The officer observed surveillance of the defendant throwing objects onto the roof and re-entering the store. The defendant was identified by his enterprise mobile truck.
He has at least 3 other trespasses. Are any of them with the same complaining witness? Can you please tell me?
Yes. I'm just gonna check the address real quick, Your Honor. I don't believe that this is the same complaining witness. It's a different store and a different complaining witness, Your Honor.
Yeah, you're gonna, because you have.
He never said anything that they gave him any warning or told him to leave. I know that he did.
Yes,
Did
Your
he say
Honor.
anything of this? And I missed it?
Yes, Your Honor, there was looks like this was one deputy and the defendant returned to the store after being given a verbal criminal trespass warning due to a theft. And the complaining witness and another deputy from precinct 6 gave that verbal warning at approximately 2:10 a.m. And this occurred at 3:17 a.m.
Okay. Mr. Woodall, I'm going to find that there's probable cause to go forward with the case. Don't go back to this place. If I find that you become a danger to my city, if I find that you go back, it's not going to go well for you. Do you understand?
Sir,
Do you have the ability to hire lawyers, sir?
not at the moment, not this time.
Okay, I'll have you fill out an application. I'll take a look to see whether you qualify. Do you mind filing those bond conditions, please? Okay, he's going to give you an application. I need to know everything about you, and then we'll have you sign a receipt and then take a seat in the jury box, sir.
So Barbara says, if I ever got in trouble, I'd never get off as easy as all these people, not walk out of courtroom. Is that your way of telling us that if you ever get in trouble, you're going to do it right and be all in? That's kind of how I read it. And the Casman, is it like a hot day in Houston or something for all these people to be wearing shorts? We're going to hit our first 100-degree day probably today here in Arizona, and I wouldn't wear shorts to court, but I don't know.
Speak English, sir.
Yes, sir.
About it, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Your Honor, on April 5th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a crash and was told that the complaining witness was following the suspect vehicle. The law enforcement officer located the suspect vehicle and initiated a traffic stop. Suspect vehicle continued driving erratically, changing lanes without signaling, and running red lights. Vehicle then crashed into another vehicle and came to a stop. The total distance that the defendant evaded for was approximately 10 miles. Law enforcement officer made contact with the driver, the defendant, and observed red bloodshot eyes and a 6-pack of beer. One beer was open in the center console and was 90% empty. The defendant consented to a breath specimen and blew 0.14 and 0.13.
Sobriety test, or it was an accident? They didn't do any?
They did not completely fill the sobriety test, Your Honor. I believe just that they, after the evading and the crash, coupled with the red bloodshot eyes, and the beer in the vehicle, they took him in for suspicion of DWI.
You said there was an accident, right?
There were 2 accidents, Your Honor. The defendant, there was an initial crash and that.
And then he took off and then he
took
got
off
out
and crashed again. Yes, Your Honor.
By that, I'm going to find that there's sufficient probable cause to go forward with the case. Do not drive. I'm ordering you now not to drive at all. Do you understand? I'm also going to put a monitor on your ankle so I know that you're not consuming alcohol. If I find that you consume alcohol or illegal drugs, I will put you in jail. No more PR bonds. Do you understand? I don't know why you have the smirk on your face, but you're charged with a very serious felony. You're now looking at a lot of time on this case. There's alleged alcohol in the car, 2 accidents. If you watch the news, every day someone dies from an alcohol-related collision in our county. It's a very You will be randomly tested for drugs as well. If I find that you're using, it's not going to go well for you. Do you understand? Any prior DWIs?
No.
No, Your Honor. And
License isn't eligible.
It's not.
It's not eligible.
No.
You're not allowed to drive. You're going to be signing an affidavit with me today promising me you're not going to drive. Mr. Barrera, if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months and a $500 fine every time you drive. Do you understand?
Yes, sir.
How old are you, sir? Did you want to apply for a court-appointed lawyer?
I can apply.
You want to apply for a court-appointed lawyer, okay? I'm going to give you an application. What are you doing with yourself these days, Mr. Barrera? Did you graduate from high school? What grade did you make it to? We're going to work on that. I need you to fill out this application for me. I'm going to appoint your lawyer today. You're going to sign a receipt with Ramona, and then you're going to get with Fleischer for your bond conditions. I need him to fill one out. Yeah. What's this? Is this on docket today?
No, Judge, it's
Then they can wait.
Okay.
The lawyer's been waiting a long time. If she's not on docket today, no.
We have some here.
Lawyers, anyone? Come on. Thanks for being patient. Hey.
Mr. Nolan, he's got this goal for.
Okay. Talk to me.
I think it was bond conditions, right? And if,
Judge for Nava, we sent him for a test yesterday. He was having trouble submitting one, but he finally did. It came back presumptively for THC, benzodiazepines, and cocaine.
Come up.
Well, fine, be that way, Judge. I hate it when he does that. I don't know. It didn't used to be that way, but people started giving him guff about it, and now he just turns off the stream as soon as anybody demands it. The Linkman, I don't know if that was the High Lady or not. Maybe. Timing would be about right, potentially. Oh, no. He's back now.
Life and everything. So the allegations of the.
Where is Mr. Nutt?
He's right here.
Come up.
The allegations are that there was one test where he tested positive for alcohol at a 0.04 and 0.05 level, Judge. I've spoken to him and made explicitly clear that there's no tolerance, especially in your court, Your Honor, for any alcohol at all. This is the only positive alcohol test that he's had in the 5 months or so that he's been on bond in your court, Your Honor. He's clean now, has been clean, is not drinking.
Am I supposed to take that for?
No, but if he were to be tested for ETG or anything today, he'll be clean, Your Honor. He's
There
been,
was 18 skin tests between February 24th and March 31st.
sure. So I've also spoken to him about that. I'm trying to see what we can do.
DWI second, I've ordered you not to use. You've skipped 18 tests and now you're testing positive? Am I supposed to just let you go?
I would ask that he be released. He's gotten a new job, Your Honor. So his dad just got his legs amputated, Your Honor. He's been trying to take care of his dad, which is what's been going on in his life. And he's the main caretaker for his father.
These are things you think about when you're on bond for DWI second. We've ordered you not to use. Actually, it's his third DWI because he's had one dismissed. Oh. I don't know what I need to do to get a hold of you. You know, it's unacceptable.
And I've explained this, like I said, I've extolled all of these, these values to him and talked to him about this, especially in the wake of the BVR being issued to him. And how important it is that he can't miss a single blow. And, I'm telling him, and I have told him and
Send
admonished
him for a
him.
test right now.
Yes, sir.
Come back. Okay, let's go, Felicia. Let's send him.
Yes, Judge.
Okay.
If he has to come back, then we'll talk.
Yes,
He
sir.
comes back.
Thank you.
All right, great.
Yes.
Great.
Judge, we just have a remand order. Davis.
Davis.
Okay.
Did you want a bond?
No, he's got a pre-signed waiver, parole violation. Just wanted to make sure everything was on the right exit.
You've explained it to him? Is he accepting your explanation?
Yes.
Okay, good. Okay, here you go.
Yeah, thank you. Thank you.
I'm sitting in for a test. He's got to come back. Okay, Mario. I need a translator.
Judge,
Yeah, you
yes,
mind
unfortunately,
calling
we do require a
Yeah, I'm calling one right now.
Okay, fantastic.
Harold.
Be on standby.
I'll let you know as soon as I get there. Don't forget to.
Oh, yeah, it's getting this right. I know.
Judge, do you have any more applications?
Juan Reyes.
Mr. Said, come up or talk to me. Yeah.
Judge, I was gonna do a plea on Jorge Gomez. We were originally gonna do the probation and we were just gonna do a time served instead. He's spoken to probation in Bear County. It's his understanding they're gonna reinstate him and extend it. They did file a new motion to adjudicate yesterday.
In his case?
Yes, but he said he's very recently spoken to the probation there. So my suggestion to him was try to get those treatment options from his felony probation in Bear County because they're gonna extend it. Because I didn't want a situation where he's transferred there and then he has a failure to report on a brand new probation here. It's just gonna be a headache.
Yeah. All right.
Okay, thank you, Judge. And would you be willing to waive the DPS fine for him? I'm appointed.
First or is it second?
It's a first, Judge. Thank you, Judge.
So, to qualify, you have to be at the poverty threshold to qualify. If you make the kind of money that you make, you don't qualify. This life is not about how much money you make, it's about how much money you spend. Spend too much and you get into a hole, we can't foot the bill for the taxpayers,
Yes, Your Honor.
Make good money, which is great, right?
Yes, Your Honor. It's my wife.
Stop. I don't want you to say anything. Just, so we're going to give you time. There's a gajillion and one lawyers out there. It's about you finding the one. It's like buying a car. You don't go, when you're starting off in life, you don't go buy a Lamborghini or a Bentley or a Ferrari. You go to Toyota, Honda, and lawyers, 99% of them will put you on a payment plan as you go. You have to negotiate with them. Don't take them at first blush. There's literally a gajillion and one lawyer, criminal defense lawyers out there. So if you don't find one or one's not willing to negotiate, go to the next one because there's tons of them out there. Okay. All right. We're going to give you 30 days. Don't wait. There's a lot of timing requirements with the DWI. So don't sit there and, I'm going to wait until 29 days to start looking. You're only hurting yourself. Okay. Okay. Good luck. Oh, I would also probably look for one, the immigration as well, if you're not a citizen of this country. Okay. Good luck. Hey, I have to go to court at 6. You got one right here. Oh, other than this gentleman. We got one more right here. Okay, yeah, I'm gonna grant that one regardless.
Which way I'm going?
On Barrera.
Valerio?
And we still need it, Ramona, we still have to do this too.
Yeah.
We'll do this right now, yeah. Can I give you cause number, State?
Yes, sir.
She checked yesterday. She said,
Mr.
okay.
At 255-7402. Say it again? Yeah.
Okay.
Carol Lopez, come up. Oh, I didn't see this. Oh, no. I'm sorry. Yeah, just have her. I didn't realize that he's out. All right, come here. Let's do this real quick. We'll get you done.
Thank you, Judge.
Sure. All right. Good morning, Mr. Gomez. So he's got two cases, right? The trespass
Judge.
and the
They're
DWI?
getting a time served to the DWI. They're dismissing the criminal trespass.
Now, if I'm correct, you're on felony probation in another county, right?
Yes, Your Honor.
Is it?
It's Bear County, Judge, it's aggravated robbery.
You're looking at 20 years in prison, you know, not only that, it's a 3G offense, meaning that if they revoke you and send you to prison, you have to do half the time before you're even eligible for parole. So if they send you to 12, you're doing 6 before you're even eligible. Now you got these two cases. When is it going to register to you that we mean business, that you can't continue like this unless you want to go to prison, of course. You need to understand that by pleading guilty to these cases here now, they may use this to revoke your probation in Bear County. Do you understand?
Sure.
Now, I don't know if they're going to, but they can. And I'm going to tell you, the more cases that you pick up, the higher likelihood you have of that happening, because they are going to be like, well, this guy just, doesn't take us seriously.
Sure.
You are giving up a lot of rights by entering into this agreement, Mr. Gomez. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the rights to appeal. Once you accept this agreement, you're done with this. You can never come back and change this or undo this. When you're in a car and you're driving and you get pulled over, the first thing an officer does is they look at your criminal history. If they roll up to your car, they look at and they see that you're on probation for an aggravated robbery, you have been charged with a trespass and a DWI, and they come up to you. You think it's going to go well? So I probably wouldn't give them the ammunition from now on. If you want to get lit, don't get into a car. Even if you've had a sip of alcohol, you understand.
Yes, sure.
As part of the agreement, it's 20 days in jail on the DWI, 16 days credit, and they're going to dismiss the trespass. Is this how you understand it? You also, I'm going to make a docket notation that I have advised you that by pleading guilty to these offenses, it's possible they revoke your probation in Bear County. Do you still want to do this, or do you want to wait to see what happens over there?
To do this.
You want to do this?
And he's been in communication with probation over there, Judge. And basically, they gave him the option of either being unsatisfactorily terminated. Is that correct, Mr. Gomez?
Yes, unsuccessful.
Or he can have it extended and attempt to get it successfully terminated. And so he chose to have it extended to pursue that option. They were already aware of these cases, correct?
Yes, Your Honor. Yes.
How do you plead to the driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to the agreement. I'm going to suspend your license for 180 days. Do not drive. Otherwise, you're going to be right back in jail.
Sure.
All right? Good luck, sir.
Thank you, Judge.
Okay, Judge. I'll see you later.
Have fun.
I have to go. That's all.
Ms. Lopez, come on up. Good job. Have fun. I'll hit you up next, Harold. All right, you are Carol Lopez.
Yes.
Ms. Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Judge. On March 26, 2025, an officer was dispatched to a crash on Antoine Drive in Orange County, Texas. The officer learned that an unknown party called 911 at the time of the crash. It was informed by another officer who arrived on scene that the observant clinic being treated by ambulance. The officer informed the other officer that the defendant had already been transported to receive medical care. After spoke with the will witness, who stated that the defendant was a sole occupant and struck the witness's vehicle causing damage. The will witness stated they observed strong odor of alcoholic beverage emitting from the defendant, and the will witness came in contact with him. The will witness stated that the defendant was still in the driver's seat at the time of their interaction, and that it was clear that the defendant was intoxicated. The will witness reported that the defendant had slurred speech, was incoherent, and not making sense. The police stated to the will witness, "I don't know why." The witness reported that he was being called and defendant itself on a crash. And immediately after that call, the defendant grabbed a bottle of vodka and consumed the entire thing in front of the will witness.
What?
Yes, Sherman. That's what happened.
She took a bottle of vodka and consumed an entire bottle of vodka in front of the will witness?
That's what I have here. The will witness noted that the defendant drank the alcohol bottle as if the defendant was drinking water.
Just when you think you've heard it all, man. I mean, really.
The officer observed an empty bottle of chocolate vodka, and then went to the hospital to make contact with the defendant. The officer observed the strong odor of alcohol beverage from the defendant, observed that he could have slurred speech and glossy eye. The officer read the DIC form for the defendant when the defendant became coherent, and it proceeded to a breath test and blood test. The hospital discharged the defendant, and the defendant was transported to the Joint Processing Center, but was unable to perform the state arrest for sobriety test due to the defendant's failure to follow instructions and to keep the defendant's and the inability of the defendant to keep her head up. The officer took the defendant's failure to follow instructions as a refusal. The officer was unable to get the defendant to stand upright to perform HCN, and due to the physical condition, the officer did not ask the defendant to perform walking turn or to walk stand. The officer concluded, the officer offered the opportunity to provide breath and blood. The defendant declined to provide breath or blood, and the officer proceeded with a residual search warrant for the defendant's blood. The officer was advised, the officer was advised the blood would be ready in 2 to 3 days. The officer noted that that's all I have.
Do you have blood back or no?
I do not. I'm not sure if that in the is referring to. The warrant was presented to the hospital, Your Honor, and a nurse advised that with blood, I guess, been ready for 2 to 3 days. The officer.
Do you have any pride to guys?
There was one in Caldwell County that was dismissed, Your Honor.
License?
License is. No.
This is the judge.
It's not on docket. I have to give you a case number. You ready? 255-7402.
Thank you.
If you speak English, right?
Yes.
If you have a problem with alcohol or drugs, now is the time for you to address it. Because stop. There's nothing that you can say at this moment. I'm warning you now, because this is the only one that you're going to get. I will do everything in my power to protect my city at all costs. I don't care who you are, what color you are, if you're a small farm animal. If I find that you're using, it's not going to go well. Do you understand?
Yes, sir.
Now is the time for you to try to get any help if you need help, because I don't know you. I've never met you before. All I know is what they're telling me. And if that's in fact true, now is the time for you to address it. I am going to put a monitor on your ankle so I know that you're not consuming alcohol at any time. I will not entertain any excuses like it's mouthwash, it's a tequila lollipop, hair dye. I've heard it all, and excuses mean nothing to me. If you consume, it's not going to go well. Because of I don't want you in the car driving. You're not allowed to drive. Do you understand?
Yes, sir.
If I find that you do, it's really not going to go well for you. I am putting now a restriction on your license that you are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught, and I'm sending this notice to DPS, so everybody, every officer in this state knows, if they pull you over and they don't see an interlock, they will take you to jail. Do you understand? And then you and I will have problems. Just don't.
Judge, this is Carl Lopez first,
Yes, ma'am.
and then you said no driving?
Correct.
Thank you.
And then a scram, please.
Yes, Judge.
You have the ability to hire a lawyer, ma'am. We will give you an application. You missed court once. A warrant is now in effect for you because you missed court the first time. I will reinstate your bond now, but this is the only get out of jail free card that you get. If you miss court again, you violate any of these conditions, you will stay with me. And I don't know who you have in this life, but if you don't have anyone to pony up $5,000 to $10,000, you will be stuck like Chuck until this case is over. Do you understand? All right, come up. We'll have you sign this. I need you to fill an application. Deputy Miranda's going to give you an application and we'll go from there.
Judge, I initially no driving, her license is out.
Harold,
Yes, Judge.
talk to me.
Was there for Miss Washington, Your Honor?
Is she on
Kenyatta
docket
Washington?
today?
Yes, we just saw her last week and y'all set her for this Friday.
Come up, Miss Washington. Did we talk with her already or no?
It was last week, Judge. It was a bond violation. And you already spoke with her.
Okay. So I guess, I don't know why we have it here. So we'll just set it off for 50 days. Don't use. If I find that you use, it's not going to go well. Do you understand? Yes or no? So I'm setting her for 4 weeks because we gave her the conditions in February. So I'm
Yes,
going to
sir.
do 4 weeks. If she tests positive again. Okay.
Yes, sir.
Okay. All right. Well,
Thank you.
we'll see you in 30 days. You must take a test in 30 days. You understand? Don't use. See you in 30 days.
Thank you.
Hi. Thanks,
No
Carol.
big huge, Your Honor. Thank you.
Oh, no. I need to get you a date. Hold on.
I was going to ask if we could avoid the week of May 5th,
Avoid the week of May 5th?
if we could.
Yes,
Yeah, I might
absolutely.
be out of town.
Of course.
Sebastian, Joseph Jones,
She has a BVR today. I'm setting her off for 30 days to take another test. So she must be here in 30 days to take a test. And then not the week of May 5th. Day, not the week of the May 5th, because that's Harold can't make it.
That's Miss Washington, Judge?
Yeah, and so,
okay.
Yeah, we never do.
Ready on Monday?
Judge, not the week of what?
yeah.
Yeah, that's the other thing. Permission to approach.
Yes, please.
Your Honor, I'm here on Shamar Anderson.
Okay,
So I just wanted to approach on this one. I was talking to the coordinator. It is an older case.
it's 370 days old.
So he doesn't live in Harris County, Your Honor. And so that's what really kind of has led to the delay. So I just got appointed today. I would ask for at least 30 days to be able to review everything.
I mean, I'm not gonna, this case is 400, he's taken off on multiple occasions. Is there an offer in this case?
There is a time served, Your Honor.
Is that it?
They haven't talked to the complainant, Your Honor. They haven't called the complainant.
We've not made contact with the claimant, Your Honor.
I'm getting my ass chewed because of all these cases that are so darn old, so no more. So I'll give you guys 2 weeks. You need to get in contact with the complaining witness if it's needed, because I don't know.
It is late.
So you've got 2 weeks,
Yes, Your Honor.
so no more. So get on it, and then he's gotta be back in 2 weeks and it's clear trial on that day.
It's plea or trial that day.
Yes. 370 days old. I mean, really, I have to say when at some point. I can't just keep letting it go.
Well, can I ask you this, Your Honor? Since he does live in San Antonio, if that is our, can we get 3 weeks?
Come up.
I just want to make sure, I don't want to create an issue with him and his travel. So I just want to be clear with the court. I understand, Your Honor.
Literally, Mr. Anderson, you literally bend over backwards to not put people in jail. Your case is nearly 400 days old and it's time to make a decision on what to do. I'm not gonna sit here and play any more games.
Yes, sir.
2 weeks for you guys to meet to decide what you want to do with this case.
Sir.
But at 370 days, that's it. Cases should be resolved at 180 days.
Sir.
Do you understand?
Sir.
So be back here in 2 weeks. Let us know what you want to do. You must meet with them to figure out, look at the evidence, see what's out there and just make a decision. It's not hard. It's a trespass. It's not a capital case, you know? If it was something serious, then yeah, but I mean, it's a trespass. It's not a capital trespass, you know? Okay. All right, guys.
I'm not inclined.
Please.
Hi, Judge. Judge, I wanted to see if we could bring out Mr. Joshua Sweat. He's a young man that we've been resetting from earlier this week.
Okay, let me do this real quick.
Sure.
Finally got the translator. Mario's been waiting since 9 in the morning.
No worries, I'll be here.
Mario,
Yes, Judge, I'm ready.
who's your guy?
This is on Mr. Jose Villalobos, Your Honor.
Villalobos.
Ya, señor, yo soy su intérprete. Por favor, conteste todo en voz alta.
Your Honor, if I may, this stems from a bond violation report here where there's 2 readings of positive alcohol on his portable device that he currently has, Your Honor. I've discussed this at length with our client, and as you may understand, in our experience, we certainly hate to provide any type of excuse whatsoever when it comes down to this. Discusses with our client, he's adamant that this was stemming from consumption of medication during a period where he was unfortunately under the weather, Judge. And he did send me the pictures of the medications that he consumed. It's Theraflu, Dayquil, the typical over-the-counter medications, Your Honor.
None of that is going to test positive for alcohol. You know,
I've admonished him on this, Judge. I made it abundantly clear this should not be something that, should even come out like this way. This is something that we would graciously ask the court here to consider seriously admonishing our client, Judge, but allowing him to remain on bond. I think we're close to a resolution on this case, Judge. And we're looking to hopefully get this resolved as quickly as possible.
here's what I'm gonna do. I'm sending you now for a drug and alcohol test. I've ordered you not to use. We've had pre-trial tell you not to use. And you now have on 2 different occasions tested positive for alcohol. So either you don't care about court orders or you have a problem. I'm sending you now for a drug and alcohol test. You were to come back, and it's now late, so we'll have you come back Monday with the results. Do not use.
No.
Do you understand?
Entiende. Entiende.
Okay, I'm sending him now, Mario, and then we can regroup on Monday, okay?
That'll work, Your Honor. That'd be huge.
Wow, yeah.
Okay.
You're supposed to
Thank you,
come
Judge.
back here Monday, and I'm sending you for a drug and alcohol test. If you fail to take the test, I'm going to issue a warrant for your arrest. Do you understand?
La su arresto. Entiende.
You're to come back Monday, and then we'll discuss the results. If you fail to come back Monday, likewise, you will be arrested. Okay, take a seat for me, sir.
Basically, Your Honor.
Thanks, Mario. See you.
We can judge. Take care.
Yeah.
Okay.
Good, on. Yes.
I'm sending him for a test now. Monday, he comes back. Hey, Ramona. If you want the 3 weeks, you can have the 3 weeks, okay? But it's clear problem.
I don't know, B. Davis. I don't know if I'd want to be in front of Boyd. She can be scary, and your odds are fairly high of walking away with some jail there, or prison. I don't know. I feel you, though. I mean, I don't know. I don't know if I want to be in front of her.
Great. My understanding, well, okay, I do have to advocate for my client, Judge, when he first
I'm
signed
not
up.
gonna begrudge you for advocating for your client, absolutely not.
A couple things. When he first signed up, I admonished him. We went through the paperwork. We talked about what to expect. He was expecting a pickup date of April 16th. And so all of a sudden, he wasn't cleared medically for some reason. We
Well,
don't.
because he was allegedly coming down, right?
I don't know who makes that determination.
If you're in a state that it's not an appropriate state for transport, he's subject to injury to himself. Transport, it's a huge liability for them. So they want to make sure that you're in the right state of mind for when you do get transported. I mean, it's only logical because the last thing they want is to get sued because they try to take you and you're not in a right condition and something happens, right?
Sure.
Do you know that every time someone comes to transport you from this state to the other, it's $4,000 to $6,000. It's not cheap.
Sure.
Someone has to pay for it, right? A lot of times they'll come after you to foot the bill. So I don't know. But regardless, it's a 30 days, right? He's a Michigander.
Correct, Your Honor.
When are they coming?
They said they can be here with up to 10 days, so the reset date is the first, but they should be.
What is it?
The reset date for this case will be the first, for
Okay.
3 days, but they probably should be here for that, thanks about up to 10 days.
Okay, so it's still within the 30, right?
Correct, Your Honor.
Okay. I mean, it's still within the 30, which is what the statute says. So no one's doing anything to you that would harm your interest in any way. We want to make sure that you're you can be done in a safe and effective way, you know?
I understand.
So hopefully within the next 10 days.
Hopefully, Judge, yes. Okay.
Okay? He has a pre-signed waiver anyways, right?
Yes, and it was entered on the.
Even if I wanted to give him a bond, I can't.
Judge, the only thing that, the issue that.
Sign waiver.
That brings up though is we have him required, we require him to sign the waiver of formal extradition and everybody signs this.
No. There's a document that I signed ordering
The future Hunter?
for his to be remanded. There's no real formal document for him to sign. It's a document they filed to me and I signed it for him to go get picked up. So theoretically, there's nothing for him to sign.
What I'm speaking of is the actual waiver of formal extradition proceedings that's signed by him, by
They
you.
probably signed that because they didn't see that there was a pre-signed waiver to begin with, a lot of times.
Right, and that's my only issue, and we're talking about this, there's an expectation that he signs this and he gets 14 days. And this is done on all the cases. This is like the 5th time I've had to explain to somebody, hey, it's 14 days. No, it's not really 14 days and we're up here, but I signed the document, but the document says 14 days and I'm looking silly up here because we're talking about 14 days and all of a sudden it's 30 days.
But sometimes you're not going to get the document that there's a pre-signed waiver until after the fact as well. It's not that you don't look silly. You just need to advise them, hey, sometimes we documents after the fact. And that's just the way it goes, you know? Not everything is done, 100% every single time. It just.
So there's not an extension on the waiver. It's just, okay.
They have up to 30 days to come get you, right? Because it's a pre-signed waiver. You have already waived extradition. I can't give you a bond. Even I thought that you were Mary Poppins.
I was just told that Harris County honors the 14 days,
You can,
is what I was told.
are you listening to jailhouse lawyers?
No, I actually, remember the last time you said sometimes we don't read the fine
I
print?
told you, don't listen to other people. When there's a pre-signed waiver, statutorily, it's 30 days. They have to come get you. The 14 days is really 30 days. We do it as a courtesy. So in reality, it's 30 for everyone.
Sure.
We just, because we have so many people in jail, as a courtesy, we give 14 days. Okay?
Thank you.
All right, thank you. So he's reset to 5-1? Okay, thank you, Judge. Appreciate it.
You're the best, Ricardo. I gotta run the course next, man.
I have to enter for a plea.
Okay, let's go.
Okay.
Mr. Hunter?
Are we just doing time served?
No.
Just. Here you are. Paying all these $10,000 bonds here, $5,000 bonds here, and here you come in wearing a Louis Vuitton jersey, really? Really? After all the money the county has spent on representation for you, you're coming in here with a Louis Vuitton jersey? Oh, this is wonderful. Have we done a TRAS?
So he has a prior TRAS, but I think it may have expired and we'll need to.
And the prior one recommended like that. But you're.
One way or the other, it's going to stop. All I'm asking you to do is be clean. That's all. It's got to happen one way or the other. Do you understand, Mr. Hunter? You now stand charged with, again, with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you a 12-month deferred. Deferred is a type of probation that if you complete it successfully, you do not end up with a conviction on your record. But you can't tell people it was dismissed. It's not dismissed. It's if you complete it successfully, you don't end up with a conviction. For you to complete this successfully, you must do an effective decision-making class, a gun safety class, and a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. forfeiture of the weapon, no drugs, no alcohol, 40 hours of community service instead of the community service. If you do a parenting class, I will consider the 40 hours of community service waived. I would like the T-Rise done pretty quick. Like, okay, that'd be great. Yeah. Since he's here, it's probably the best thing to do. Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You could be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You are stuck with us until you complete it successfully or it gets revoked. I'm going to tell you now, Mr. Hunter, that I can hold you for up to 3 years. We will do everything in our power to ensure that you get clean and remain clean. Do you understand? You hear me? How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that for 12 months. We're going to send you now for a TRAS. You can come back. We'll see what it says and we'll go from there. Okay.
Judge, without going too far into attorney-client communications, I have admonished Mr. Hunter that if he violates any term of the deferred, that the state can start a motion to adjudicate where he would have a hearing in front of you, and you can sentence him up to the year in the Harris County jail.
If you violate this agreement, glad you said that because I forgot to say that. If you violate this agreement by not doing what you're supposed to be doing, by testing positive, picking up a new case, having a gun, a warrant will be issued because we will file a motion to revoke your probation. We will have a hearing here. And if they prove it to me, you are facing a year in jail. Do you understand? But me, I'm not interested in jail. I'm interested in having you be clean. And we will do that however it can happen. If you're able to do it on the outside, wonderful. If you're not able to do it on the outside, we have facilities available for you at no cost to you. You understand? Now is the time. Okay, good luck.
Thank you, Judge. May I be excused?
Yes, ma'am.
Justin Castro? For a moment. You go to questions.
Okay, if Judge is going to court 6, it's probably time for us to go on about our day. To be honest with you, we've got a busy day here at the courtroom, busy weekend here at the Courtroom Files bunker. Tons of stuff to do for our other businesses. Got to catch up on that. And there's some things I want to do specifically for this live show that hopefully I can get to this weekend to kind of improve it a little bit. No promises there. We'll see if I have the time. I had a lot of fun today. I hope you guys did too. We stuck with Fleischer quite a bit, but everybody else finished early, and he's always entertaining, so it was good. A lot of good back and forth in the chat today. I appreciate that. Thank you to our new subscribers. I know there were a lot of new people here today. I hope you come back and join us again. Again, we're here live Monday through Friday, 7 a.m. Pacific, 10 a.m. Eastern, and you can always find us here at the Courtroom Files for all the other videos and shorts and everything else that we have. We've got a ton of content for you. And thank you, once again, a special thank you to our new channel members who signed up today. That's very much appreciated. So go about your business. Have yourselves a great weekend. Again, appreciate you being here. Hope to see you again Monday.